Jason A. Geller is the managing partner of Fisher Phillips San Francisco office. Fisher Phillips is one of the largest U.S. law firms representing management exclusively in the areas of labor, employment, civil rights, employee benefits, and immigration law. The firm has 32 offices with 300 attorneys. Jason represents employers in all facets of employment law matters. He has considerable experience defending employers in litigation involving claims under the Family and Medical Leave Act, the California Family Rights Act, the Age Discrimination in Employment Act, the California Fair Employment and Housing Act, and California wage and hour laws. Jason has also defended employers against whistleblowing and retaliation claims, including claims under the California Whistleblower Act, the False Claims Act, and various provisions of the California Labor Code. Jason has extensive experience defending employers in federal and state courts, as well as in investigations by the Equal Employment Opportunity Commission, the DFEH, United States Department of Labor, and the National Labor Relations Board. In addition to defending his clients in litigation, Jason frequently counsels employers to assist them in avoiding litigation. He regularly advises clients on leave management issues and the interactive process for employees with disabilities, reinstatement obligations under various leave laws, and wage and hour compliance. Jason has prepared employee handbooks and a variety of agreements, including independent contractor, employment, confidentiality, and trade secrets agreements. His clients are involved in a variety of industries, including assisted living, independent living facilities, construction, manufacturing, architecture, professional services, agriculture, technology, retail, and restaurant industries. Jason was included in Northern California Super Lawyers in 2015. Jason's professional activities include board member, Northern California Human Resources Association, East Bay Chapter, member of the Marin Human Resources Forum from 1995 to 2000, member of the Labor and Employment Section of the San Francisco Bar Association, board member and legislative co-chair, Employers Advisory Council of the California Employment Development Department, member of the Labor and Employment Section of the State Bar of California, and member Advisory Committee on Employment Law Jury Instructions of the Labor and Employment Section of the State Bar of California. Jason is regularly sought by media for commentary on employment law issues and is a frequent writer and speaker for numerous professional associations. To stay current on Jason's regular activities and articles, as well as numerous other news and events, visit the Fisher Phillips website. From there, you can visit the Fisher Phillips resources page and Jason Geller's direct page. This way you can access his regular articles and updates. To inquire about any of the issues Jason discusses in the program today, or any other questions, please feel free to email him at jgeller@FisherPhillips or to telephone him at 415-490-9020.
Good afternoon, everybody. This is Jason Geller with Fisher Phillips, and we are here on behalf of the Center for Continuing Education to discuss an always timely topic, the Family Medical Leave Act and the California Family Rights Act. Now, what's spawned this webinar in part has been the fairly recent update to the California Family Rights Act regulations in July of 2015. And during the webinar today, we're going to cover important topics that are really addressed by both the Family Medical Leave Act, the FMLA, or the California Family Rights Act, CFRA. In particular, we're going to discuss the rise of leave rights in general, and then segue right into important issues concerning eligibility under the FMLA and CFRA, including important changes that we're seeing in terms of rules concerning employee eligibility, in particular in California under the California Family Rights Act. But as I indicated earlier, a few moments ago, the FMLA and CFRA are strikingly similar. We will, though, cover today some important distinctions in those laws as well. In addition, we will cover calculating the leave entitlement under the statutes, as well as important issues for employers and employees on responding to leave requests as well. And finally, we will discuss important issues concerning the employer's right to obtain medical certifications for employees requesting leave under these laws, as well as important issues on reinstating employees after leave and the requirement that the employee potentially submit to a fitness for duty examination or a release to work note from the doctor. These are all issues that have been addressed by the updated regulations under CFRA and will also be covered and have been covered by the Family Medical Leave Act. So the rise of leave rights. In general, as we've seen throughout the land really, the rights of employees to certain protected leaves of absence have certainly expanded. And I think some of us may recall a recent presentation by President Obama in one of his recent State of the Union addresses, where he commanded Congress to provide, for example, paid leave, paid sick leave for employees across the land. And that's just really the tip of the iceberg. As many of us know, when practicing in California, the leave rights for California employees have certainly expanded. And these begin, of course, with their rights under the California Family Rights Act and the Family Medical Leave Act. But employees also have rights to paid or to leave under the pregnancy disability leave law in California, as well as similar statutes throughout the country, as well as leave as a reasonable accommodation under the federal Americans with Disabilities Act, the ADA, or for those in California, the counterpart to the ADA, the Fair Employment and Housing Act, or FEHA. In addition to these major leave laws that we confront employers and employees alike in California, we also have, as I mentioned, other minor leaves of absence under the California Labor Code, ranging from potentially leave as a reasonable accommodation for employees who are requesting rehab to attend voluntary drug and alcohol rehabilitation programs, all the way to voluntary firefighter leave and leave to attend literacy education or court appearances for domestic violence purposes, to name just a few. And these are examples certainly in California, but for those of us who are practicing in other states throughout the country, must be mindful. We all must be mindful of legislated leave rights under similar state statutes, as well as local ordinances. And while we're not going to be covering today the litany of local ordinances throughout California that are proliferating, as an example only, in San Francisco, we have our fair share of employment-related local ordinances governing, among other things, the right to paid sick leave. So it's something that all employers and employees should be cognizant of, the growth of local ordinances and the expansion of leave rights thereunder. Now, before we get into the nitty-gritties of the CFRA and FMLA, it's important to cover some important issues about what is leave and what is wage replacement. And this is often something that is confusing for employers and employees alike. We all know that CFRA and the FMLA, the ADA, address protected leave entitlements for employees and the employer's concomitant obligations under those laws. In addition, though, there is also the concept of wage replacement, meaning for the most part, the leaves that I just mentioned, and with really one exception that I can think of that's a local ordinance soon to be implemented in San Francisco, most of the protected leaves are unpaid. So there are occasions, though, when there is wage replacement during the otherwise unpaid leave. And some examples would be private disability insurance or state-provided or government-provided disability insurance benefits. In California, for example, we have a wage replacement benefit for the bonding when employees are bonding with newborns, which it's a misnomer, but it's referred to as paid family leave. It's really a form of wage replacement for employees who are out to bond with a newborn or care for a seriously ill family member. And then, of course, there are other forms of wage replacement, such as vacation or paid time off or sick leave. And it's important to note that these concepts or vehicles of wage replacement will not expand the leave entitlement under CFRA, FMLA, or other statutes protecting leave. Rather, these are forms of wage replacement to assist an employee with some compensation when he or she is otherwise on an unpaid leave of absence. It is very important to make that distinction between wage replacement on the one hand and protected leave on the other, which is what is governed by the CFRA and the FMLA. One thing that is important for employers and employees to be aware of at the outset is to make the right designation of the protected leave, if there is protected leave, at the time the employee requests it. And I always suggest, and when I counsel clients, employers in this area, which is all that I do is represent employers, is to advise them on understanding what type of leave is being requested, the why, also the who is requesting, meaning is that employee eligible for any protected leave, and then of course the when, meaning when is the leave requested, what is the duration of the leave. The who, the why, and the when, regardless of whether we're talking about CFRA, FMLA, disability leave, or any other type of leave, you need to really answer these three questions: the who, the why, and the when. And it's really important for employers to be cognizant of the array of leave laws out there, as I suggested earlier about the rise of leave rights, so that the employer can understand, and it's equally important for the employee to understand, whether the particular leave requested is protected by the law. Sometimes the leave requested is not protected by the law, either because it isn't for a qualifying protected reason, the leave, or the employee is not eligible for the leave that would otherwise be protected under the law, as examples. But we really need to know, when we evaluate a leave request, what is the purpose for the leave, and is that purpose protected that is out there? And number two, it's very important for both employees and employers to understand how benefits will be handled during the leave. Will the employer be obligated to provide health insurance or other insurance during the leave? Or will the employer not be so obligated? Will benefits such as vacation or PTO or sick leave continue to accrue when somebody is out on a leave of absence, either under the law or under applicable employer policies? And more importantly, or as importantly, I should say, will the employer force the employee to use up any of the banked paid time off during the otherwise unpaid leave? Will it be compulsory use of banked paid time off or not? What does the law require? What does the employer's policy and practice require on benefits treatment in these respects? And then thirdly, at the outset when a leave is asked for, what are the employer's obligations to return the employee to work or reinstatement? As we know, and we'll talk about, The FMLA and CFRA have very, very high duties of reinstatement following a leave, but other laws may not have such high duties of reinstatement. If the leave is not protected, what is the employer's practice and policy on returning somebody to work after leave? What is the policy and practice of holding a job open while the person is out? Sometimes the law requires that, and sometimes it doesn't. The point is, at the outset of a leave request, the employer certainly should be asking itself all of these questions so that it knows how to address the leave and document the leave properly as the employment relationship proceeds and the employer is confronted with tough leave should last and whether the employee needs to be returned to work when the leave is over. Now let's segue into the topic of FMLA and CFRA. And as I indicated earlier, this webinar in part was spawned by the changes to the California Family Rights Act in July of 2015. And just a couple quick words about that. There were regulations, the CFRA regulations were updated then in large part to harmonize the California Family Rights Act with the Family Medical Leave Act to the extent that they were consistent. Now, there are certainly some differences between those two laws, which I'm going to emphasize in a moment. But the regulations in July of 2015 were really intended to harmonize the two to the extent necessary and also to expressly incorporate the FMLA regulations, which have been on the books for several years now and recently amended in 2013. So that was really the impetus for the regulations, and those of us who practice in California welcomed them. Now, subject to the differences between the laws, let's go over a few of the basics that are consistent with both. First and foremost, covered employers, at least at this point, are employers with 50 or more employees, okay? It doesn't mean just employees within a particular state. An employer can be covered if it has 50 or more employees on its payroll for at least 20 calendar weeks during the current year or 20 calendar weeks during the preceding year. Important to make sure that if you're an employer, you're conducting an evaluation there for coverage to ensure if you're really close to 50, whether you're going to be covered or not. That's number one. Number two, eligible employees typically have to be employed for at least 1 year, have been employed for at least 12 months before the leave of absence begins. Also have worked 1,250 hours during the 12 months preceding the start of the leave. And lastly, work at a work site of the employer within 75 miles of 50 or more employees. And then if the employee is eligible there, he or she is entitled to leave, typically job-protected leave, for 3 or 4 main reasons. One is for his or her own serious health condition. The second is to care for a seriously ill family member. The third is to bond with a newborn, could be an adopted child or a child who's placed in foster care. And then lastly, under the FMLA, not so under CFRA, are the military-related leaves of absence for injuries that are suffered in the course of active duty, or for what we call military exigency leave, where an employee needs time off that's occasioned by a call-up to active duty. And then there are also several technical we need to be mindful of regarding designation of the leave, giving notice for the leave, asking for medical certifications, and the like. A couple other points about the basics that we need to remember. These leave laws confer an absolute right to the employee to get job-protected leave within the rules of the FMLA and CFRA. There's no argument by the employer that the leave cannot be accommodated, for example, which might be an argument the employer could make under the disability laws. This is an absolute right. It's different. The employee is entitled to it if he or she is eligible. The other thing to note too is that often when an employer is designating FMLA leave. Oftentimes in California, the leave is going to be run concurrently with the employee's rights under the California Family Rights Act. And there often are, by the way, important overlaps that also occur when leave is being designated as FMLA or CFRA. One of the chief differences out here in California, many of us may know, is that pregnancy-related disabilities are not covered as a serious health condition under the California Family Rights Act. More about that in a moment. But generally speaking, absolute right to leave, and often there will be a concurrent or simultaneous leave under both the FMLA and CFRA. Now, what are some of the important distinctions between the California Family Rights Act and the FMLA? Well, as I mentioned a moment ago, under the FMLA, a serious health condition, which is it's a technical term, requires an employee to have that serious health condition or his or her family member to have a serious health condition in order to be entitled to leave. Now, under the FMLA, serious health conditions that are related to childbirth or pregnancy are covered by the FMLA, are subsumed by the definition of serious health condition. On the other hand, though, in California, under the CFRA, they are not. Under California, pregnancy-related serious health conditions are really covered by our separate pregnancy disability leave law. So that's a very important distinction between the FMLA and CFRA. The other related difference is that, as we suggest on the slide, that under CFRA, once an employee's pregnancy-related disability ends and the baby is born or the baby has been adopted or placed with the employee through a foster care, for example, the employee may be entitled to what's called post-birth bonding leave under CFRA to spend time for the birth of a child. And so or adoption or placement in foster care of the child. So in essence, or in practicality, what that means in California is that an employee may be entitled to up to 7 months of protected leave, 4 months of protected leave under our pregnancy disability leave law, and then an additional 12 weeks of leave to bond, post-birth bonding with the newborn. Another important distinction between the CFRA and the FMLA is that unlike CFRA, FMLA has the military-related leaves that we mentioned earlier. CFRA does not cover the military-related leaves. California has separate leave laws for military-related leaves. So that's an important distinction. And in that regard, under the FMLA, the maximum leave entitlement could get up to 26 weeks in the where military-related leave is involved during a typical leave year. Not so under the California law, CFRA. And then finally, of course, a big distinction which has really been mitigated by the striking down of Proposition 8 and case law is that under California law, care for registered domestic partners is a protected family care purpose. Wasn't so under the FMLA until recently. We're now same-sex spouses are protected under the FMLA. So really not as much a distinction as it once was. There also are some other related distinctions between the CFRA and FMLA. The one I will mention before we move on is that unlike the FMLA, under CFRA, an employee who is asking for intermittent leave to bond with a newborn child is entitled to take that leave in increments of smaller than 2 weeks. On 2 different occasions, the employee is entitled to take that intermittent leave in increments of fewer than 2 weeks. And then thereafter, the bonding leave can be taken in increments of 2 weeks or more. And this is all to be done without employer consent. The opposite is true under the FMLA, where generally the bonding leave would be taken in one block of 12 weeks unless the employer consented otherwise. We don't have that requirement under CFRA, so that's another important distinction to cover. So let's talk about eligibility in general among employees. I mentioned earlier that at least 1 year of service to the employer before the FMLA, before the leave is to begin. And that 1 year of service, it doesn't have to be consecutive. It can be broken up as long as the leave is, as long as the employee has been employed with the employer for at least 12 months before the leave begins. And there's a retroactive review of in the past 7 years, the employee needs to have worked for the employer for at least 12 months. And certain credits are applied for military-related leaves of absence during that period where the employee would otherwise be eligible and credited would have any military-related leave under the federal USERRA, for example, credited against the 12-month requirement. The employee also needs to work 1,250 hours, must have worked at least 1,250 hours during the 12 months prior to the date the leave begins. And the 1,250 hours is typically measured by actual time worked under the Federal Fair Labor Standards Act. In California, though, under our new regulations, we look to hours were actually worked. Of course, that's relevant for non-exempt hourly employees. For exempt salaried employees, the 1,250 hours is presumed unless the employer has strong evidence to indicate that the exempt employee had not worked the time. And then, of course, there's the protection against, protection or the requirement that the employee work within 75 miles of 50 or more employees. And the concept here has been under the FMLA that where an employee works at a small outpost for an employer, he or she shouldn't be eligible for protected FMLA leave because it's a smaller facility and it's really a resources question. More about that in a moment because California law deviates from that to some extent now with the updated regulations. Then, of course, covered employers, they need to have 50 or more employees throughout the country, whether the employee is part-time, full-time, or on leave. Employees who are on the payroll in that regard will be counted for the 50 employee threshold for coverage purposes. Now, again, that doesn't mean that the employee asking for leave is herself eligible for the leave, but it does mean that the employer is covered under FMLA and CFRA and will have important obligations to respond to leave requests, even to those employees who are not eligible. So the basis for the leave, as I mentioned earlier on the basics here, are the birth, the placement for adoption or foster care of a child, the family care for a child, spouse, or parent with a serious health condition, or the serious health condition of the employee that makes the employee unable to perform the essential job functions. And then under the FMLA only, of course, serious injury or illness or qualifying exigency related to military service. So let's talk a little bit more about these eligibility requirements under some of the changes that have been required under California regulations for CFRA. And very important for those of us even who do not have employees in California or who may, that this is still very much relevant for FMLA coverage as well, and the need potentially for concurrent leave. So under the new regulations, this is an example of an expansion of the potential joint employment status of an employer. And essentially the new regulations have incorporated into CFRA a fact-intensive totality of the circumstances evaluation of whether one or more entities should be considered one employer in order for that group of entities, if you will, to meet the 50 employee threshold to be covered by the FMLA and CFRA. And it's a fact-intensive inquiry, but one thing that's expressed in the new regulations is that common ownership and management, which is typically a factor to be considered in joint employment status for this purpose and others, is not necessary. And important things to look at would be the sharing of services and the sharing of employees among different entities, or and this is an example might be where and I see this a lot in the hospitality and the restaurant industries in which I represent several employers, where there might be multiple entities that share a common human resources department and often have employees working from one property to the other. That may be a classic indicator of joint employment status. And oftentimes employers may unwittingly conclude that, well, they have one entity running this property and another entity running the other, and these entities all have far fewer than 50 employees each. We don't have anything to worry about. That conclusion may be a perilous one, given the changes to the CFRA regulations, which expressly incorporate or expressly make joint employment status something that can be achieved in a multiple entity situation. And it's also reflective of a desire to expand eligibility, frankly, and coverage under these laws on a joint employment theory. Now, there also were some other important changes for employee eligibility under the California Family Rights Act. And one thing to mention here is that when the employee makes the leave request, the employer needs to determine eligibility. Now, eligibility under what I call the 50, 75-mile rule that we talked about earlier, where the employee must work within 75 miles of 50 or more employees, that evaluation is determined at the time the leave request is made. However, the eligibility criteria for months of service and hours of work in the preceding leave year, or 12 months, I should say, the 1,250-hour requirement or the 12-month requirement, those are made, that evaluation is made at the time the leave is to begin. Not when the leave is requested, but at the time the leave is to begin, an important distinction. And the regulations also make this, make an important change under CFRA, at least. Here, an employee may not be eligible under the length of service requirement, the 12-month length of service requirement, when the leave first begins, but maybe once the leave is underway. So, for example, an employer may permit an employee to take time off during her 10th or 11th month of employment. And after 1 month of that time off, it could be vacation, it could be leave for another reason, but during that first month of time off, she's still on the payroll and then could achieve eligibility once that 1 month has been completed, at which time she would be eligible under CFRA. All continued leave under this current leave request would be covered by CFRA. And it should only be designated, of course, the CFRA leave should only be designated to the extent the employee becomes eligible once she has gone out on a leave. So an example of an expansion of employee eligibility under CFRA. Likewise, another example under CFRA, under the new regulations, is a relaxing of the 50, 75-mile rule. And this essentially is now determined by where the employee could be determined by where the employee receives assignments, to whom the employee reports, what the employee's designated home base is. So an example would be an employee who works from home in California, and she's the only employee working in California. The employer is headquartered in New York and has 100 employees in New York, and the employee receives all of her assignments in California from the New York headquarters. Well, guess what? That employee may now satisfy the 50, 75-mile rule because she's theoretically within or conceptually within 75 miles of the 100 or more employees in New York by virtue of the fact that she receives all of her assignments out of New York and not some other location. So very important for the employers who work or have employees in California who work remotely, that now those employees may become eligible under CFRA under these circumstances. Now, another change on eligibility, as I alluded to earlier, of course, spouse expressly includes same-sex couples under the new regulations in CFRA. Of course, not an issue anymore under the FMLA with the changes there and the striking down of Proposition 8. Now, calculating leave entitlements. So this now is measured, it's typically 12 work weeks within 12 work weeks of CFRA protected leave, could be 26 weeks, of course, if you're under the FMLA and there's a military leave component. Under CFRA and FMLA, though, generally it's 12 work weeks within a leave year. However, the employer chooses to define its leave year, be it on a rolling method, an annual basis, a calendar year, an anniversary basis. That's up to the employer, but it's 12 work weeks of leave. And under CFRA, the regulations were changed to add the requirement that leaves that for employees with variable work schedules now are entitled to an evaluation of their 12-week leave entitlement by looking back over the preceding 12 months to determine how much the employee typically worked in order to determine what 12 work weeks means within the means under CFRA. So the leave entitlement, this is an expansion. It used to be a review of the preceding 12 weeks. Now the employer must look back the preceding 12 months to determine the average hours worked for purposes of calculating leave entitlement for variable schedule employees. Now, another important change under CFRA regulations is that normally worked overtime will count against the leave entitlement. So that would mean if you're reviewing a work schedule for purposes of determining what 12 work weeks means under CFRA, if the employee regularly worked overtime, then the overtime is going to be potentially considered as a part of the 12 work week leave entitlement. Again, a focus on hours in California, not just work weeks. On the other hand, voluntarily worked overtime would not count towards any leave entitlement. And whether it's voluntary or regularly scheduled, everybody's guess is as good as mine on what that means. I think certainly employers are going to want to look at work patterns and schedules and draw inferences on whether it was really something that was compulsory and compulsory overtime worked on a very frequent basis, or something that was presented as an option for the employee to take. So that'll be very fact specific. The other thing to mention too under CFRA regulations, and something also that is always relevant under FMLA, is whether additional leave beyond the 12 work weeks would be considered or must be considered as required as a reasonable accommodation for a disabled employee. Under CFRA, the regulations now expressly say that an employer is required to assess to potentially extend leave beyond the 12 work weeks if the employee says he can't return at that point in time because his condition is persisting. Very important to be aware of that under CFRA and under FMLA. Now, calculating leave entitlements under the CFRA regulations of July 2015. And this was an important change, essentially, that for employees who are asking for that dreaded intermittent leave, which often can be, I say dreaded because it can be hard to manage at times. Those of us on the employer side can appreciate it, and the employee side as well, when it's potentially unpredictable intermittent leave. Can be challenging. Now, where it's physically impossible for the employee to engage in or to receive intermittent leave during a given work week, then that whole work week will be charged against the employee's FMLA and CFRA entitlement. And that the example that the regulations give is a flight attendant who says that she wants to work or he wants to work intermittent leave for 2 days during a given work week, when during that work week that employee was scheduled to fly to Hong Kong and back, and therefore it would be physically impossible for that employee to actually work intermittent leave during that week. Under those circumstances, that entire week would be charged against that employee's leave entitlement under CFRA. Now, responding to leave requests. This is something that is very, very important for employers and employees, that everybody on, whether you're an employee or an employer, understand your notice obligations and your designation obligations. And typically, the employee provides the notice of the leave, hopefully 30 days in advance. The employer then timely responds to that leave, now under CFRA, like the FMLA, within 5 business days of that leave request. And then the employer will hopefully comply with the designation rules using the correct forms to designate and give the employee notice of his or her rights and obligations under the FMLA and CFRA, as well as alerting the employee to any obligations to provide a medical certification, or to have to undergo a fitness for duty examination at the time the employee returns to work. And so a major change under CFRA now is that it's no longer the 10 calendar days in which we need to respond to a leave request, but 5 business days. Now, another important point to mention under the CFRA regulations is a change regarding notice and what is sufficient notice. And the regulations and case law, both under FMLA and CFRA, are legion on deciding or evaluating what is adequate notice of a need for an FMLA or CFRA request. And typically, and the regulations indicate this, that generally an employee who says, I need time to take vacation, I'm going to be out on vacation, that is certainly not enough to put an employer on notice that it needs to designate and respond to a request for FMLA or CFRA leave. But certainly these situations are very fact specific, and if an employee gave more information, and the scenarios are varied, and we could speculate and give hypotheticals until the cows come home on this. But typically, if an employee were to say, I'm sick, I won't be in today, that's generally not going to be enough to trigger a response by the employer. But if the employee shares more information about the purpose for the absence, that may very well trigger an obligation for the employer to respond to the leave request, meaning it would put the employer at least on inquiry notice that the leave may be sought for an FMLA and CFRA purpose, triggering all the designation obligations. So very important for employers to be mindful of the new regulations under CFRA concerning what may be considered adequate notice for the leave request. The other important thing, too, under the regulations are critical CFRA regulations, and this would be true under FMLA, is that we have critical posting obligations, both in our handbooks and on our walls, about what FMLA and CFRA require. And under the CFRA, if the employer does not, under the new regulations, appropriately give employees notice of CFRA rights, both either in a handbook if the employer has one or through posters, the employer may be deprived of its defense or ability to deny leave to an employee who did not give the requisite 30 days advance notice for the FMLA or CFRA leave. Very important notice and posting obligations that have really been ongoing, but certainly underscored by the new regulations. Under the new CFRA regulations, there's been an expansion of the definition of serious health condition, the main thing being that it's relaxed. They have relaxed the standard for what is a serious health condition under CFRA. And one example is that there's no longer an actual requirement of hospitalization, but only the expectation that there may be an overnight stay. And as we mentioned on the slide, in the FMLA, it's still required that there be actual hospitalization, at least under certain definitions of serious health condition, not just the expectation. And there's also been a relaxation under the CFRA regulations over what is continuing treatment, which, as we know, can also be sufficient to satisfy the definition of a serious health condition. And there's been a relaxation under the number of doctors' treatments that need to be provided in order to meet these very technical definitions. Medical certifications. This is something that most of us probably know, that either under FMLA or CFRA are not mandatory. The employer can designate FMLA or CFRA leave without requiring the employee to provide a medical certificate within 15 days after the employer has made the request that the employee provide it, as a condition for granting the CFRA or FMLA leave. So the need for a medical certification is a permissive one. The employer is not required to do it. If it chooses to require or condition the leave on the receipt of a medical certification form, we all know that the employer must include notice of that requirement in the designation documents at the time it is responding to an FMLA or CFRA leave request. Now, in California, this is another area where there are some important distinctions between the FMLA and CFRA. And if you are a California employer, you should certainly be using all of the California updated forms on the Department of Fair Employment and Housing website for medical certification forms and for designating leave as qualifying potentially under CFRA and FMLA. In fact, using the federal forms now for designating CFRA leave under the new regulations is discouraged, or in fact not allowed. We need to really use the California-based forms. So that's important to step number one to be aware of. An important other distinction is that in California, unlike the FMLA, under no circumstances may the employer ask for the diagnosis of the particular condition. That's not the case under the FMLA. If the employee volunteers the diagnosis, that's up to him or her, but employers in California cannot ask for it, and our forms expressly tell the healthcare provider not to disclose the diagnosis. And along those lines, in the spirit of privacy protection under the California laws, the new regulations, as we see on the slide, will say that an employer is limited on the types of inquiries it can make of an employee's doctor. Now the employer cannot clarify what's in a medical certification, but can only ask that the doctor authenticate it, meaning that the doctor confirm that, yes, in fact, he or she signed the form and it is what the doctor says it is. That's a very narrow scope of inquiry, and frankly, a situation should be very few and far between when an employer wants to be communicating directly with the physician or treating healthcare provider of an employee. And so this is an example of limiting the employer's ability in California to have those communications, and frankly, it's saving employers from themselves, because there are a lot of pitfalls and problems when that dialogue happens between employer and physician. And then certainly, if appropriate notice, as we say, was given to the employee that leave may be denied if the medical certification form is not timely provided, if that notice is given, then the employer could potentially deny CFRA protected leave, and also deny FMLA leave for that matter, where an appropriate medical certification is not timely provided. Recertification and fitness for duty examinations under the new regulations, and the FMLA also addresses employers' ability to do this. An important requirement under the new regulations in California is that an employer cannot condition the return on a previous receipt of a fitness for duty examination. Now, that's different from a release to work from a doctor. This is a fitness for duty exam that is narrowly tailored to cover only what the employee is actually required to do for his or her job. So if the employee's essential job duties are to lift, then the fitness for duty exam would be limited to the lifting of the requisite weight, for example, that the employee would normally be doing in his or her job. And what's important is that the right to reinstatement is paramount, meaning the employee comes back to work, she gets returned to work thereafter, the fitness for duty exam can be provided. And like the FMLA, it is very important at the time of designation, if a fitness for duty exam will be required, that the employer notify the employee of that requirement and should enclose with the designation documents under FMLA and CFRA a job description so that the healthcare provider will be fit to conduct the fitness for duty examination that is consistent with business necessity and narrowly tailored. Very important. The other important change under CFRA is, of course, the limitation on an ability for the employer to seek a second opinion for the based on the medical certification provided by the doctor. And frankly, I can think of very few circumstances where clients of mine have opted to seek a second or third medical opinion in an FMLA or CFRA scenario. But there technically are rights to do that. In California now, you need a good faith, objective reason to do it. The standard has been heightened to actually discourage the invocation of this process. It used to be a reason to doubt the veracity or the content of the medical certification. So that's been a heightened standard to justify it under the California regulations in July of 2015. Now, substitution of paid time off is also something that there are some important differences between the FMLA and CFRA. Generally speaking, the FMLA allows employers to force the use of banked paid time off, whether it's sick time, PTO, or vacation, when an employee is on an otherwise unpaid FMLA leave. The rules are different in California, and as we mentioned here, an important change in the CFRA regulations are that if the employee is receiving some type of disability benefit under a private disability benefit plan, for example, the employee is not on unpaid leave, and therefore the employer would not be permitted to compulsorily force the use of bank time off under those circumstances, namely because the employee is not on an unpaid leave in that circumstance and wouldn't be able to invoke or require compulsory use. Now, other important distinctions are that normally under California law, under CFRA, sick leave or banked sick pay, if it's truly sick pay, can be required to be used by the employee for the employee's own serious health condition. But for family care purposes under CFRA, it cannot be forced to be used by the employee unless the parties agree. So there needs to be an agreement there if necessary. And then an important distinction for those of us who have employees in California and outside is that where you're dealing with the pregnancy-related disability, it's important to note that under the pregnancy disability leave law in California, the employer cannot force the use of paid time off or vacation by an employee who's taking time off for a pregnancy-related disability. That's not the case under the FMLA, remember, because pregnancy-related conditions are covered by the FMLA, and the FMLA, in theory, would permit an employer to force the use of PTO and vacation. Not so under California law. The only time under those circumstances where compulsory use of bank time off can be used is when the pregnant employee has sick time available. That can be forced to be used. Retroactive designation, the California Family Rights Act, and this has been the case under the FMLA for some time, now expressly permits the employer to retroactively designate the leave as FMLA and CFRA qualifying. So if the employer failed to do that, failed to appropriately designate the leave, and this is important, and there was no harm to the employee as a result of that failure to designate. In other words, the employee, but for the employer's failure to designate, the employee would have taken the leave anyway, and the employer otherwise complied with the law by returning the employee to work and providing for continued payment of any existing health insurance, then there won't be any prejudice to the employee and retroactive designation would be permitted. Now, be very careful, though, before doing that, because it is certainly discouraged. Retroactive designation is discouraged, and where the employer was on notice previously of the need to provide CFRA and FMLA qualifying leave and didn't designate it, its rights in this respect may be limited. So it's not certainly a free pass to fail to designate, but there is a safe harbor, if you will, where there's no prejudice to the employee. Now, under the CFRA, and this is true under FMLA, very, very high reinstatement or return to work rights. And in California now, it's expressly required that employees be advised that it's a guaranteed right of reinstatement, and needs to be put in writing to the employee if the employee requests that the right to reinstatement be put in writing. Now, these are some technical requirements that can lead to interference claims under CFRA, so it's important for the employer to be aware of them. The other thing that is very important here is that if the employee, and one of the main defenses, I should say, probably other than key employee status, and we'll talk about that in a minute, really the only main defense to returning an employer to work is for the employer to prove that the job would have ended anyway. In other words, but for the employee taking time off, the position would have been eliminated anyway, so there's no job for the employee to return to. And you might imagine that's a very high burden to meet, and employers want to make sure that they've got sufficient facts to defend that position if they deny reinstatement on that basis. Now, another important change, or another change to the CFRA regulations in this regard, is that if for some reason the employee was no longer qualified to return to work because he or she needed to maintain a certain license, like a nursing license or something like that, and the license expired, the employee needs an opportunity, a reasonable chance to renew that license before reinstatement can be completely denied. And this obviously creates issues about licensure on the one hand and complying with those laws and complying with CFRA and FMLA on the other. But just another example of high duty of reinstatement for employees in California. And I would mention also that I have often an employer will argue that after or while the employee is out on a CFRA and FMLA leave, the employer recognized that, hey, we can do without this person. We've been able to do fine. Let's go ahead and eliminate that position and deny reinstatement on that basis. That can be a risky position to take for obvious reasons, because and this is incorporated into the regulations. The fact that the employee, the new regulations, but the fact that the employer was able to manage without the employee during the leave is not a justification to deny reinstatement under those circumstances. Now, the key employee exception. This is something that typically applies to employees who are in, or does apply to employees who are within the highest 10% of employees working within 75 miles of the employee's primary place of employment. And the concept generally about key employee status is that the employer cannot return the employee to work without causing, quote, substantial or grievous economic injury to the employer. Pardon me. And that is certainly, as my intonation should suggest, a very, very high standard. And so one thing to note about this concept is that when an employee is a key employee, and is otherwise eligible for CFRA and FMLA leave, the employee is entitled to that leave. It's not a question of denying leave. What the employee may not be entitled to is reinstatement to the position, because it would cause substantial and grievous economic injury to the employer. And It's also important, the regulations make clear that if the employer does not, during the designation process, identify the employee as a key employee and identify or state that the employee may not be returned to work because of his or her key employee status, if that is not provided, that notice is not given, the employer is not going to be able to rely on the key employee defense to reinstatement. So notice requirements are very, very important. The other thing too is that if the employee asks to be in fact reconsidered and asked to come back to work, the employer is going to have to give the employee that opportunity before denying reinstatement. And what's important also to note under the new regulations under CFRA is that there isn't any precise test, of course, for what substantial or grievous economic injury mean, and that the employee is still going to be entitled to the health insurance benefits during the leave period, even if reinstatement were denied. Remember, the leave must be given where the employer has an option, and it's a limited option at best, as I've said, is to deny reinstatement to that employee at the time the leave would have ended. The benefits and other rights under the CFRA and FMLA need to be continued. Under the new regulations, and this is under CFRA and certainly true under FMLA, there are new posting requirements that employers need to comply with, and electronic posting is also permitted. It's really critical, as I mentioned earlier, that all handbooks and other policies be updated to reflect the new rules under CFRA so that the employer preserves its rights under the CFRA to deny leave or require employees to otherwise comply with its requirements. Without the compliance with these posting requirements, very easy to comply with, folks, the employer's rights will be significantly curtailed. So what does an employer and an employee do at the end of the day in view of these updated regulations? Well, certainly employees and employers need to be completely familiar with not only the regulations, but also the employer's policies on requesting CFRA and FMLA. Also, all posters and poster locations, meaning, these posters should be placed in conspicuous areas and the handbook should be updated. That's very critical. Also important, employers need to ensure that they're using the correct forms, the correct medical certification form under California, as well as the designation forms under California, so that the leave is appropriately designated under both FMLA and CFRA, where those leaves are running concurrently. And for the most part, absent a pregnancy-related situation or a military-related leave situation, CFRA and FMLA leave will generally most often run concurrently. It's also important to train managers and also let employees know of the requirements for giving notice of FMLA and CFRA. Remember, where the leave is foreseeable, an employee is required to give the employee, at least their employer, at least notice of the need for qualifying FMLA and CFRA leave. And if the employee fails to give that requisite notice without justification, such as for a medical emergency or otherwise, the employer is going to be able to deny the taking of the FMLA and CFRA leave potentially. So it's important that everybody be aware not only of the notice requirements, but also of the need to promptly designate the leave or respond to the leave request within the 5-day requirement under the new regulations. And lastly, it's very important to document all leave requests, whether it's under FMLA, CFRA, pregnancy disability leave, the ADA, or otherwise, so that the employer and the employee understand what their respective obligations are going to be going forward. And with that, I will conclude my presentation. Thank you very much for attending. My name is Jason Geller, and I'm very willing to discuss with anybody who has any questions about these topics, which are certainly broad, and I appreciate the 1 hour time frame in which I needed to present them. So I'm very available for questions about any of these topics, or if you need assistance with leave management issues, please feel free to reach out to me. My direct phone is 415-490-9020, and my email is jgeller, JGELLER, @FisherPhillips.com. Thanks again for attending.